Have you been any big developments in the world of personal injury this week?
Yes, Indiana actually has. We have a Court of Appeals case that was decided. And in this case, the Court of Appeals addressed an issue of whether a photograph can be entered into evidence, under what circumstances it can be entered into evidence. And in this particular case, it was an injury case where regrettably, there was a young woman who had very, very serious injury in a motorcycle accident. But in this case, the plaintiff tried to get a photograph into evidence showing Menards, a company, hauling a wooden pallet behind a truck. And in this situation, the motorcycle hit a pallet and she was injured in that way. But the trial court did not admit that photograph into evidence, and the Court of Appeals decided that the trial court was correct and that the plaintiff did not do or did not have the necessary evidence to get that particular photograph admitted to the jury.
Now, we do not know any of the facts of this case beyond what we read in the Court of Appeals, but there's
Correct.
two things jump out at me when I read this. Anytime there's an accident with a motorcycle, it's just the chance for catastrophic injury is just so great. Am I right about that?
Yeah, it's you don't need to be an attorney to figure some of this out, but when you do what we do, it is front and center. Or if you're an emergency room doctor or nurse, you see what happens with motorcycles. And so there are some incidents like this where if people are in a pickup truck and hit a pallet, they're probably not going to have a scratch on them. You never know, but with a motorcycle traveling at highway speed, hitting a wooden pallet, bad things happen, and there's no seatbelt or car to protect you during the crash.
So the second thing that pops out at me is I've been a trial attorney 14 years, and you've been even a little bit longer, but getting a photograph into evidence is not hard. It's not rocket science. What are the foundational questions that are necessary to get a photograph into evidence, Mr. Allen?
Yeah, well, let me play devil's advocate and challenge you a bit. Sometimes it is hard. It depends on what facts you have. So what you need to show the court under the rules of evidence is that the photograph is legitimate. Essentially, that's the big overriding question: is can this photograph be trusted? Do we know enough about the context? And so those questions are, who took the photograph? When was it taken? What exactly is depicted? What and the purpose for the photograph. Sometimes evidence can be admitted for one purpose, but not another. And so there are foundational questions that you need to ask. There's sometimes some magic words. For example, does this fairly and accurately depict the condition of et cetera, et cetera? You're laughing because it's attorney words, but you have to play the game and jump the hurdles. And if you don't jump those hurdles, or you can't jump those hurdles because the facts just are not in your favor, and you are not able to know when that photograph is taken or what it actually depicts, then you cannot get that into evidence.
Yeah, and so I was trying to read between the lines, and it looks like maybe they had a photograph of a Menards truck. In a way, a pallet could fall out, but they were not able to connect it. That was the truck it fell out of, or is that kind of what was what I would interpret it as?
Yeah, as you mentioned, we have the facts that are mentioned in the Court of Appeals decision, but not every fact in the case. We don't have the trial transcript in 3 or 4 or 5 days of trial testimony before us. But from what the Court of Appeals mentioned, there was at least circumstantial evidence that the pallet was from Menards. There was an order ticket, some type of form or delivery receipt of something of that nature that was found in the area. And Menards did admit that was their receipt, a delivery receipt. And it did show that that it was delivered, I think, like 2 weeks before the crash. So it's possible, certainly, that it could have been a Menards pallet. And then the photograph that the plaintiff attempted to get into evidence was a photograph of a Menards semi hauling pallets in an open, kind of like a flatbed trailer behind the semi, in which, if they were negligently secured, then one of those could have come off and then caused this crash. Now, another interesting wrinkle into this is that the plaintiff was riding on the motorcycle, her boyfriend was driving, and one of the defendants in this case was the boyfriend. And the boyfriend said that he saw something immediately before the crash that flew up out of a truck. So that seems to be inconsistent with the theory that it was from a Menards flatbed trailer. And so maybe that played into it as well. And who knows what the true facts are. But in the big scheme of things, what I think could have potentially changed the result in this case is if an attorney got involved right away after the crash.
How would that have made a difference? Getting an attorney involved immediately. Tell me about that. Because I mean, this is a tragic case. There's serious damages, and the plaintiff, who was injured, no fault of her own, she's riding on a motorcycle. She got a verdict of 0. So I mean, this is, for me, I feel it's a tragedy. What could an attorney have done differently, or what do you think could have made a difference?
Well, one of the most important reasons to hire an attorney, or speak to an attorney, I should say, immediately after an injury, is to preserve evidence, to investigate, to determine what the facts are, and make sure that the evidence doesn't disappear. So, for example, what we do is we send a very carefully drafted video preservation letter to certain parties. In this situation, we would have sent it to Menards and required them to preserve video, receipts, various evidence in the time period before the crash. And so if this were a Menards pallet on the road, we'd have a much better chance of establishing that and showing that there was someone who pulled away from Menards, a half hour before the crash. A worker threw a pallet in the back and didn't secure it, whatever facts you want to imagine, and then show that person, figure out who that person was through credit card receipts, for example, and then find out where they were going, and if their house is, where the crash is in between Menards and their house, then right, you have some pretty good evidence, even if that person denies it was them, that was why the crash happened. And so there's all types of evidence that can become stale, that completely disappears if you don't take the right steps immediately to give yourself the best chance to preserve that evidence. But sometimes that evidence isn't there no matter what you do. But at least in that situation, you know what the facts are, and perhaps you can avoid litigation if there's really not a realistic chance of prevailing.
No, and for all Jameson and I know, the attorneys did all of that, and there was dead ends. But just we're reading off a sparse. Morgan fixed that. We're reading off a Court of Appeals opinion, and it's just struck both of us that a 0 verdict for someone that literally did nothing wrong. It's tragic. It really is. And so, I appreciate you talking with us, Jameson. We can't end it on a sad note like this. Give me something positive. What other cases were there? Give me even if it's a small chat about something.
Well, let me just speak a bit on just being careful in the wintertime as we're heading into winter. Slip and falls are a part of our practice. It's just a reality that ice and snow can cause injuries, and of course, not every slip and fall results in a lawsuit, nor should it. But as a homeowner, you need to be cautious and just make sure that for health reasons as well as legal reasons, that your sidewalks and your driveway are taken care of, and also business owners as well. And there was another case that the Court of Appeals decided regarding a church, where churches get extra protection. So as you go to church, make sure that you're extra careful, because I mean, I don't think most people want to sue a church if you get hurt, but you need to know that churches don't have the same responsibility to care for parking lots and sidewalks, et cetera, as a homeowner does, or Menards would if you go to Menards to pick up a Christmas gift. So it's kind of strange how Indiana law in some ways treats schools, corporations, police officers, municipal corporations and police officers differently. Indiana law treats churches differently, but just be safe out there. The main purpose of personal injury law is to keep people safe, is to change behavior, so that if there is a verdict against a company, for example, that company changes its practices, become safer, and other companies looking at that verdict decide to make it safer, and everybody's healthier, and we're in a better place because of it.
Thank you so much, Mr. Allen. I look forward to talking with you next week. You have a great day, buddy.
Thank you, Attorney Lopez. Happy New Year.
Got a really interesting case from the Indiana Court of Appeals this week. It's not for publication, meaning it's not binding precedent. It's kind of cool for lots of reasons. Two of them talks about voir dire and also final arguments. And so, voir dire is a fancy way of saying jury selection. The purpose of voir dire is to discover whether any prospective juror has an opinion, belief, bias that would affect or control his or her determination of the issues to be tried. So basically, when people are trying a jury trial case, you're trying to get people that don't have biases. You're trying to get people that are at least going to listen to the evidence. And so you want to talk to them, like, do they have any preconceived notions? I've done lots of jury trials. Mr. Crows, who's joining us, has done lots of jury trials with me. Mr. Crows, what makes this case kind of fun and unique?
So what makes this case kind of fun is, in voir dire on this case, the prosecutor goes through a bunch of different hypotheticals. And one of the things that we're not supposed to do as attorneys is give hypotheticals that lead to the facts of the case, or that are too descriptive to the facts of the case. This particular case, revolves around resisting law enforcement. In other words, is someone who's being arrested during, an officer fulfilling his duty as a police officer, basically resisting that arrest. So in this situation, prosecutor gets up and talks about a hypothetical that is almost on point with the exact facts of this case. So the prosecutor is almost trying to teach the jury, which is what indoctrinating actually means. He's trying to teach the jury about the case before the case really starts. So can you ask hypotheticals? Absolutely. It just cannot be consistent 100% with the facts of the case that are about to be tried.
Yeah, and so, in misdemeanor courts in some counties, you get a very short window of time to ask questions. So judge will be like 20 minutes. So as an attorney, you want to try to get an idea of how people are leaning one way or another. And, hypotheticals are allowed, but, in this particular case, it's resisting law enforcement. He pulled away from the police. The prosecutor asked the jury, hey, if someone pulls away from the police, is that resisting law enforcement? It touched too quick. And so as someone who sat in the defense chair, and I've seen these prosecutors do these hypotheticals and get so close, and they touch the line, close to the line. I'm so happy that there's a warning shot. And this is from the Court of Appeals. This is not binding, but I mean, it's definitely three judges saying, hey, stop it. And I think that's awesome. Matt, what was the other issue in this case that was kind of interesting?
The other issue is arguing facts that weren't in evidence. And this is specific to opening argument and closing argument. As you know, we do a bunch of jury trials at our firm, and we happen to, opening and closing are huge portions, giant portions of the actual trial itself. It's when we actually get a little soliloquy, or we get to talk to the jury about how we view the evidence, or what we believe the evidence is going to show. But it actually has to be, evidence, especially in closing argument. You can't argue something that hasn't been, presented. In this particular case, they were talking about resisting argument, and the prosecutor goes on his, little closing argument soliloquy, and kind of walking through what was shown at the trial. Hey, I asked these officers, why would you try and do a leg sweep? In other words, just try and trip a defendant. Why would you try and do a leg sweep instead of just walking in and say using your baton or say using your taser? The officer had apparently testified. I wasn't at the trial, but what I'm gathering is officer had testified, hey, because we want to use the least amount of pain or induce the least amount of pain as possible in order to secure a defendant. I think up to that point, arguing from the prosecutor is okay, but then at this time, he takes it one step further and he says, he could have just went in there and shot him, or this is how people die, this is how people get shot. I think that's where they took it too far. That's arguing facts over inevitable evidence. And I think, with everything going on in the world right now, you had the George Floyd case, you have everything, the Black Lives Matter movement. I think that starts kind of crossing the line as to, there's nothing in the evidence that suggested that guns were ever drawn, that they were ever pointed, that it ever needed to escalate that high. It was more or less, why do you get to this point? Why would you not do this? Why would you not do that? So that was kind of interesting. Again, another warning shot from the Court of Appeals, again, unpublished opinion, but it's another warning shot saying, hey, you guys got to stop basically trying to argue things that never came out in trial.
And I've done a lot of closing arguments, and even if you have your closing argument outline ready, you know what you're going to say and how you're going to say it, you still have things at the top of the moment that you're going to say. And so it's hard for me to, I'm happy the Court of Appeals has reasserted, don't argue facts, not in evidence, but I can sympathize with the prosecutor doing something like this just because you're trying to make a persuasive argument with all the facts. And, again, this was a misdemeanor case. And typically the judges are like, hey, you got 10 minutes to get all your argument in. So you got to jam a lot of stuff in there. So I can understand how this happens. And, I don't think that this was a particularly egregious or wrong, but, hey, you have to argue the facts because that's what the jury's there to decide. And it's not just a free for all. You can only argue what's in the evidence. So I love cases like this where it specifically tells prosecutors, hey, back off, because, so many cases are pro-state. It's just overwhelmingly, sometimes the defense attorney feel overwhelmed how pro-state some of these opinions come out. And I'm sure that's just my perspective, but I love it when prosecutors are told to back off, even if it's an unpublished opinion that didn't really change the outcome. Matt, do you have any parting words?
Well, if you're ever charged with any kind of misdemeanor or felony cases, it's always important that you get the right representation, somebody that's willing to fight for you and that knows the newest case law. So give us a call. Feel free, 317-632-3642. And remember,
always
plead the fifth.
Hey, Zach, this past week, there was a huge case on expungement decided by the Indiana Supreme Court. As you and I both know, expungement law is still kind of new. And to see opinion by the Indiana Supreme Court is huge. To my knowledge, there's only 2 or 3 cases total decided by the Indiana Supreme Court. So this definitely got our attention. Zach, walk us through the case.
Okay, so what the Supreme Court was trying to figure out is whether or not certain cases for expungement are not eligible. More serious cases that involve sex or violent offenses, or cases like the one that the Supreme Court dealt with that had to do with serious bodily injury, you may not be eligible for expungement. So the person in this case, he was charged with a series of crimes, and some of them involved serious bodily injury, but the charge that he was ultimately convicted of was burglary, which had no charge of serious bodily injury in there at all. It wasn't an element, but what the lower court held, and the reason they denied the expungement, is because serious bodily injury was involved. It was in the facts of the case. And so the question that the Supreme Court had to decide then was whether or not a case that involved serious bodily injury could be expunged, even if the person wasn't convicted of a crime involving serious bodily injury. Does that make sense?
It does. And so, Zach, you and I have both been prosecutors. We've seen cases where there's 10 charges, 20 charges, Boone County, we love them up there, but even the DUI, they charge 10 things. And so just because someone's charged with something at the beginning, that does not mean at the end, that's what they have. So if you go to trial and you win everything, you walk away. But if you do a plea agreement, you can agree, hey, these 10 charges, we'll plead guilty to one. And just like you said, even though the underlying case had serious bodily injury, what he pled guilty to did not. And so when I read the case, I kind of got the idea the trial judge and the prosecutor both were kind of like, he's a good guy, he deserves it, but we think that because it involves serious bodily injury, we can't do it. I mean, it's the reason why you and I are confused as well, because the Supreme Court was confused. Am I right? Tell us more about that.
Yeah, so they were confused, and they went into a whole, they read the statute, they went word by word to try to figure out how restrictive the law was. But what they decided eventually is the person wasn't convicted of a felony that resulted in serious bodily injury to another person. They really hung on the word that, and use that to show that even though this person was convicted of a major felony, in this case, a very serious crime, the crime that he was actually convicted of did not include serious bodily injury. And so for that reason, he wasn't automatically disqualified from getting an expungement. Now, it's still what they call a permissive expungement. The court doesn't have to grant it, but he's not automatically disqualified just because some of the other charges that were ultimately dismissed.
So, Zach, anybody watching this, I don't want everybody thinking that every expungement is this complicated, because they're not. A lot of expungements for misdemeanors, lower level felonies that did not involve violence, those are going to get expunged. And so what we're talking about now is permissive expungements. Zach, give us an idea of what a permissive expungement was.
So permissive expungement is for some more higher level felonies that don't follow under the automatic expungements that you were discussing. Permissive expungements are higher level crimes, such as the burglary here. It's a higher level crime. So the court has the opportunity to give you an expungement on it, but they don't have to. So it kind of, the burden falls on us and on the petitioner to show that they're deserving of the expungement, that they're turning their life around, that they've stayed out of trouble. And it's tough to get to that point. You have to go a long time without getting in any trouble before you're eligible to expunge one of these higher level crimes.
Zach, any final words on this amazing case from the Indiana Supreme Court?
I would just say, we appreciate the Supreme Court for coming out the way they did. They went into a lot of detail about how expungements are created for people to help get their lives together and help create a second chance. And for that reason, the law should be interpreted in a way that gives them more opportunities. So they came down in a way that I think supports that idea. And so I think it's pretty cool.
If you guys have any questions about expungements, give us a call, 317-632-3642. We love helping people put the past behind them. You have a great day.